All right, good morning, everyone. I think the legislative breakfast downstairs is running a little bit long, but we do, I believe, now have more lawmakers than industry people at the circle, and so the optics are a little better than they were a moment ago, and we'll go ahead and get started. Thank you all so much for being here today. I will begin by introducing myself. If you don't know me, I am Representative Rachel Roberts, the chair of this committee, and we will begin by calling to order. And there is no need for a roll call today. We'll just mark everyone's attendance. But if I could please have a motion to waive the quorum requirement. Second? Thank you very much. Before we get started with our agenda, I'd like to remind everyone that we will be continuing the new testimony process that we introduced in November. Anyone in the audience who is not scheduled to speak on an issue can fill out a testimony slip stating who they are and representing what their position is on an issue. The slips can be found on the speaker table, and you can submit them to the chair or whomever is staffing the committee, and then it will be incorporated into the minutes after the meeting. We will start today's conversation with consideration of the NCOIL Model Act in support of mental health wellness exams, a model which I am very proud to sponsor. You can view the model on page 330 in your binders and on the website and app. To provide some brief background on where we started and where we are now, we had a great session focusing on mental health parity at our summer meeting last July in Minneapolis. And after that, I decided I really wanted to keep the conversation going and hopefully have NCOIL adopt some model policy on the issue. If I'm not mistaken, that conversation last July was the first time in the 50-year history of NCOIL that a mental health, we'd really had a session that focused solely on mental health and mental health coverage. That conversation initially started with a bill I sponsored in Kentucky, which was very straightforward and simply requires insurance companies to provide coverage for an annual mental health wellness exam that is performed by a mental health professional. We then decided both at NCOIL and in Kentucky to expand that legislation to include several other related provisions, but it became clear that consensus on that was probably not realistic, although I do hope that you all will continue to discuss those issues, which were mostly around substance use disorder treatment. So that leads us to today, and I've essentially gone back to the original version, aiming to require coverage for an annual mental health wellness exam. Thank you to everyone who has provided feedback on this throughout the past year. This has truly been a collaborative effort, and I have indeed incorporated many of the requested changes. In fact, since the model was distributed at the 30-day material mark, I made one technical change in the model in section 4 on page 332 to align it with other provisions in the model. I hope that the committee will support this model, and I look forward to the discussion we will have around it today. With us here today is David Lloyd, Chief Policy Officer at Inseparable. We'll hold questions until David is finished. David, thank you so much for being here, and please go ahead.
Thank you, Chair Roberts, Vice Chair Gandolfo, and members of the committee. My name is David Lloyd, Chief Policy Officer at Inseparable. We're a nonpartisan, nonprofit organization that works to build a future where mental health policy is advanced and where mental health is treated as a critical piece of overall health. And our main priorities areas are increasing access to care, addressing our youth mental health crisis, expanding the mental health provider workforce, and building a crisis system that gets people the help they need and removes critical burdens that now fall primarily on law enforcement. So Inseparable strongly supports moving upstream and helping identify and treat people's mental health and substance use disorder challenges earlier. And therefore, we strongly support efforts to increase access to mental health wellness exams, and we thank Representative Roberts for bringing this model bill forward. Approximately 1 in 4 Americans, about 60 million Americans, have a diagnosable mental health condition, but fewer than half are receiving any mental health treatment. And the numbers are particularly stark for youth. Indeed, 3 in 4 mental health conditions develop by the age of 24, and approximately 13% of youth ages 12 to 17 have reported experiencing serious thoughts of suicide based on the most recent data. And alarmingly, 1 in 5 youth has had at least one major depressive episode in the past year. And nearly half of those 6 million youth, so nearly 3 million, did not receive any help, despite having a major depressive episode. Nearly 20% of Americans also have a substance use disorder, yet 90% of Americans don't receive any treatment. And just yesterday, there was a report that alcohol-related deaths have increased have doubled since the 1990s. And unfortunately, although teenagers and young adults are developing mental health and substance use disorders often show significant warning signs, there's really long delays in getting them the help that they need. For example, when a young person is experiencing symptoms of early psychosis, which often precedes bipolar disorder or diagnosis of schizophrenia, the average time they wait before receiving any help is 74 weeks, so about a year and a half. This is really simply tragic. During this time, young people often become sicker, and as time goes by, more difficult and expensive to treat. So ensuring access to no cost-sharing mental health wellness exams, just like annual physicals for physical health, is a critical step forward. Indeed, improving affordability is one of the most important parts of mental health wellness exams, both for families and our overall healthcare system. States like Colorado, Connecticut, and New Mexico have moved forward with mental health wellness exams because they want to increase affordability and get people help early before mental health and substance use disorders worsen and drive overall physical health care costs higher. And this is because there's overwhelming evidence that individuals with untreated mental health and substance use disorders do drive overall healthcare costs higher. Milliman found, based on claims data, that people with these diagnoses have between 2.8 and 6.2 times higher physical healthcare costs, depending on their exact diagnoses, yet most receive little or no treatment. These costs these costs are very high because we're only intervening at very late stages. And the results are frequent emergency department visits, hospitalizations, uncontrolled physical health conditions, and very often, for many folks, incarceration, which is extraordinarily costly to local and state governments. And this is perhaps not surprising, given that when these illnesses are not treated, cognitive functioning is what is impaired. So you often see that they are unable to control their physical health and overall well-being. So I urge the committee to take this important step forward of supporting the Model Mental Health Wellness Exams Act. Inseparable is happy to work with legislators in your states to advance this important issue. We also look forward to being engaged in INCOIL next year and beyond on these important issues. Happy to answer any questions you have. Thanks so much.
Thank you so much, David, and thank you for being such a big part of this bill as it has moved forward. I will now open this up to legislators. Are there any questions or comments?
Two quick questions,
Yep.
sir. What are the costs, like, to her wonderful state? And is one visit, I go for one mental checkup a year, is that really going to do anything, just one visit?
Well, one visit can help identify early challenges that individuals may have. So it can get them get them services early on when it's much more cost effective to treat these conditions.
Thank you.
If I could add to that as well. So the goal of the bill, the underlying goal of the bill is to, number one, normalize mental health care. Number two, make sure that patients have someone that they're already in a relationship with, so that should they get to a moment of crisis, they know who to call, and we're not seeing them so much necessarily at the ER and those kinds of things. And then also in states like ours to help drive mental health providers to the state where we have a shortage so that they can start to build their practices there. As far as cost goes, in Kentucky, if we were to layer this over the state health insurance plan, the maximum cost that we saw would be potentially up to $3 per month per insured.
Thank you.
Are there any other questions? Hearing no further questions or comments, I will entertain a motion to adopt the amendment to Section 4. Thank you, Deborah. Do I have a second? Thank you. I will now entertain a motion to adopt the model as amended. Do I have a motion? So moved. Do I have a second? I have a second. And then now I will, sorry, thank you all. That's not percent. Thank you, everyone. I will now entertain a motion to adopt the model as amended. We have a first and a second, and now we will move on to our voice vote. All in favor, please say aye. Aye. Any opposed? Great. Thank you, everyone. The model will now be placed on the Executive Committee agenda for final ratification. Next on our agenda is consideration of the resolution in support of establishing catastrophic savings account, or catastrophe savings accounts. That's hard to say on a Sunday morning. Next up, you will be able to review this in your books. They're on the binder, page 333, and on the website and app as well. We hope to be voting on this resolution today. We had a great discussion on this resolution at our last meeting, and no opposition has been raised. But before we go any further, I will recognize Mississippi Senator Walter Michel. Is it Michelle, Michael? I always
Yes,
get that
thank you.
wrong.
Thank you,
Michelle,
Madam Chair.
thank you. Sorry, Walter, my bad.
Thank you. I'm proud to sponsor this resolution, Madam Chair. In Mississippi, we are one of several states that's enacted legislation for catastrophic saving accounts. Just as someone can prepare for a health savings account and for expected or unexpected health care costs, one can prepare for a tax-advantaged account for natural disasters. This past year, obviously, we've seen several hurricanes, storms, floods, tornadoes, and I think now is a very appropriate time to get behind this legislation and ask for the committee's support of this resolution, please.
Thank you very much. Would any of the other sponsors like to say anything? Rep. Lehman?
Thank you, Madam Chair. I think if you were at the NCOIL NAIC dialogue yesterday, you heard me bring up the scenario of a situation where we're seeing now in the marketplace deductibles moving to a percentage deductible or a very high deductible, ACV on the roof, and you're creating almost an exclusion in some cases of roof coverage. Give me the opportunity to create something that can backfill that, and I think this is the perfect vehicle for that. But allow me to meet those deductibles and meet those criteria. So I absolutely support this resolution.
I will now open this up to our speakers for brief comments. With us here today are Kevin McAnee. I'm doing great with everybody's names this morning, of the American Bankers Association, and Paul Martin of NAMIC. Kevin, please go ahead.
Well, thank you and good morning, Madam Chair. And thank you, members of the committee and sponsors, for your diligent work. Yes, when last we met, we had not seen what we saw in the news, North Carolina, some challenges at FEMA. There has been a federal disaster savings account bill introduction that occurred November 12th when newly re-elected Florida Senator Scott introduced a version of the Inhofe bill. Just as a refresher, 10 years ago, unfortunately late Senator, Oklahoma Senator Jim Inhofe, introduced a bill that is, I think, the comprehensive standard, which is to say if your state experiences perils like wildfire or flood or convective storm, you're encouraged to mitigate against those things in which you could spend your funds on, and then you're encouraged to remediate if you suffer from that catastrophe in a way that would be very similar to a health savings account. In other words, tax-advantaged contributions to the account, tax-advantaged buildup of the assets in the account, and then tax-advantaged disbursements from the account for the things the IRS says are either mitigation or remediation. And so just like the HSA model, and again, just to refresh, 3 states have them now, South Carolina, Mississippi, and Alabama. Several states have called in between the July meeting and now saying they are going to introduce them, and so we're consulting on that question. And there is this federal legislation which will have to be reintroduced next year. Those of you who would like to read it, it is S5296. No, it will not pass this year. It's a flag in the ground, but a marker of things to come. In July, and I'll make this the last comment in the interest of time, I was lucky enough to be joined by a friend of mine, remember Kirsten Trusco, Payments as a Lifeline. The way we manage disasters in this country is not with the government, it is with charities first. And so the proposals for managing disaster in this country include provisions in the disaster savings account policy, which would allow charities to put money in this account so that it could be used for these mitigation questions. It wouldn't, the money that they put in would not be tax advantaged. The reason the charities want these accounts is because there's no better individual verification system than the financial system, the know your customer rules in banking. And so fraud wouldn't be eliminated, but it would be minimized if we did this. The other thing that's come up is FEMA and the Small Business Administration have made informal inquiries about allowing accounts for small business, sole proprietorships. As you know, a small town can't get back on its feet unless the businesses in that town get back on their feet. And so we're willing to think about that. I haven't thought about that. But it would be something else that the policy you're putting in place today would contemplate. And I suppose I'll conclude with this. Thank you. We're not voting on a bill here. We're voting on a concept. The concept would be better preparing Americans by allowing them to save tax-free over time and helping them understand that vigilance begins with them, not the government, with them. And that's why HSAs are the powerful tool that they are. Thank you very much for having me. You're nice to do so.
Madam Chair and members, Paul Martin, National Association of Mutual Insurance Companies. Very quickly, first and foremost, I want to thank Kevin for his ongoing thought leadership on this topic. He and I started this conversation years ago, and he was filling me in on what he has been working on for quite some time. I know our side of the equation from our industry, we are very supportive of this as well, so thank you, Kevin, for what you're doing. Really quick, these CSAs do two things, most importantly. As Kevin mentioned, the first thing they do is they allow consumers, your constituents, to save money by putting money into an account tax-free to pay for things like deductibles, to pay for things like repairs after a disaster. So this is not just protection of their property, this is also financial protection for them as well. The second thing they do, and I would submit perhaps even more important than that, is that they help us create a culture of preparedness and resiliency in America that we desperately need right now. My news feed, my social media feed is filled with disaster after disaster after disaster. It's not just heartbreaking, and it's not just affecting their lives in terms of their homes, but it's also affecting their finances. And so to the extent that we can come up with mechanisms to help them bear that burden, we should. We should be advocates for that. So I'm really pleased that Inquil is taking this up as a resolution so that we continue that conversation down the road. Thank you, Madam Chair.
Thank you so much. I appreciate both of you gentlemen coming to speak with us today. I'll now open this up to legislators. Are there any comments or questions? Go ahead, Senator Etke.
Thank you, Madam Chair. And just a question of curiosity. We're looking at a savings account like the HSAs where you put money in. If, let's say you had 10 or 15,000 in this account, and you never needed to tap into it, you never needed to use it, how and when would you recoup that money? When you sell your property or after 20 years, or what's the end game on this?
Happy to help, and thank you for the question. These are bona fide trust accounts, and so they're operable as trust accounts under state law. They would be federally regulated. As you put money into your account, if you have to make a disbursement for a resilient roof or a new base flood elevation certificate, or you would like storm resilient windows, or whatever it might be, whatever's allowable under the IRS code, that spend inures to the value of the structure you're trying to protect. And so recouping the money just means you're going to keep saving. And so the HSA model would apply here, meaning as you save money and save money and save money, by the time you get to a health event, so you spend that money to either manage your deductible or manage your recovery, and then you go back into the saving mode. And so the balances do go up, and when they come down on distribution, they simply go down. Recouping the money requires you to exert the same amount of diligence you used to save the money in the first place to save the same amount of money in the second place. So no one reimburses you. It is envisioned, however, that these accounts would act just like HSAs. There'll be an employee benefit as well. And so while there is a maximum annual contribution into the account under the existing proposals, the distributions and the distributions from that account can be whatever is required. But there are limitations on what can go in, because you can't just put an unlimited amount of money in the accounts. But there is no limitation on what comes out depending on the scale of the calamity that you experience.
I will follow up. I guess for a little clarity, I guess we would have to plan kind of, and I like this, but we would have to plan as we would downsize our account, because let's say you went along and now we've reached an age where we no longer are going to own a home. Mm-hmm. We'd want that account to be zeroed out, use it for the eligible deductions up to that point. Otherwise, let's say there was $5,000 left in the account and you sold your home and all of these things. What would happen to that money?
Well, I'm being placed in the position of giving unlicensed financial advice, but I will read from the bills that I know. These are bona fide trust accounts. It means you must nominate a beneficiary. Just like your HSA account has a beneficiary, it would be a disaster savings account under the current proposals if you passed away and it became your spouse's account. If under the Scott bill, they treated it a little differently, which is to say, if your surviving spouse nominated a child, for example, as the beneficiary of the account, when those funds transferred to that child, it becomes a taxable moment. But those funds would be available for the child to put in their disaster savings account. So generationally, the difference between the Inhofe approach and the Scott approach allows one generation of tax accumulation, then there's a tax moment, but that money can go into your children's account to protect the home they're in, so zeroed out in a way. The Inhofe bill is more permissive. It allows those accounts to go generation to generation to generation on the assumption that the disasters and the costs of repairing them, or the cost of repairing the damages from them, are going to go up, not down.
Thank you.
Rachel?
Go ahead.
Sorry, just a quick follow-up. At age 65, I can cash out my HSA
Yes, you
for anything I want to use it for.
That's right.
Can I do the same thing with this?
Yes,
I
you
think
can.
that's the question.
Yes, you can. Under the
Okay.
current proposals, you can.
Paul, is that your question? If there's money in that account when I turn 65 or some point, some trigger, I can take it out for any reason.
Yes. And
Thank you.
That's right. You would pay income tax on that money, but no penalties, and away you go.
Thank you. Next, we have a question from Representative Deborah Ferguson.
Thank you, Madam Chair. Can these be used for both commercial and homeowners
I'm sorry,
repairs?
could you say that one more time?
Does it apply to commercial properties as well as your residential property?
The Inhofe bill applies to, it creates this category of eligible individual, and it says any eligible individual living in a residence. And so what they mean is any single-family, multi-family, or condo is your residence. And of course, it would also apply to renters, people that don't own but rent. It would not apply to commercial structures unless we were able to create an account for, as FEMA and SBA suggested, for a small business.
I have another question. Do you have to file a claim to utilize it? Because, I mean,
No.
all the time, we'll have big deductibles, and I know that to fix the broken glass or whatever is going to be way less than the deductible. Can you utilize it for those kind of repairs, even
Yes,
though you
you
don't
can.
file a claim?
Yeah, the account, what you can put in the account, what you can use those dollars for in terms of mitigation and remediation, act independently of how you treat the insurance product or the insurance triggers.
And if you have a couple of, it's just for primary residence, or say you have a lake house, is that one HSA, or, a savings account, or do you have to have separate savings account, or does the second residence even apply?
Well, these accounts would operate like HSAs in the sense that a person owns them, and the coverage they would have would either be for themselves or for a family, and that applies in the health model. You don't have to have a property and casualty policy in place to be an eligible individual under the proposals, and so you'd be able to do whatever you wish with that money.
So you could apply it to two different residential properties?
Sure.
Okay, thank you.
Thank you. Next, we have a question from Representative Dennis Paul.
Appreciate you got good eyes from over there. I had can you pay your insurance premiums out of this account?
Under the Inhofe proposal, the answer is yes. Under the Scott proposal, the answer is no. And this is not an unimportant question, because Representative Hackett asked a flavor of that question in July, and the point would be, if you had a shock increase in the amount of premium you owed, could you use those dollars to cover the delta in it? And if that was a favorable amendment, we would certainly accept that. There would be a difficulty defining what that meant at the federal level, but we would certainly be in favor of that, because that's the idea. Now, the other way to manage that, of course, is if you have a shock increase in premium, can you mitigate that increase in premium by increasing your deductible? Because there's no question that you can use those dollars to pay your deductible. And so that might change that changes the algorithm, as you're all aware, of what the actual product costs.
Because that might be able to allow more and more people to buy insurance, as you were talking, or what Paul was talking about, making sure that we have those insurance. If you're getting it pre-tax dollars, you really save a lot of money by buying insurance then and have it.
That's
Even
right.
if you took the high deductible, deductible on that. So, all right. Well, thank you. Thank you, Madam Chair.
Do we have any other questions? Hearing no other, I will entertain a motion to adopt the resolution. Do I have a motion to adopt the resolution? Do I have a second? Having a motion and a second, we will now move to a voice vote. All in favor of adopting the resolution, please state aye. Aye. Any opposed? Fabulous. Thank you, everyone. The resolution will now be placed on the Executive Committee agenda for final ratification. Thank you to the resolution's sponsors for bringing this to us. Last on our agenda is a presentation on patent practices in the prescription drug marketplace. With us here today is Wayne Brow of the R Street Institute. I do want to note that Pharma was invited to participate in this session, and they were originally scheduled to, but due to scheduling conflicts, they ended up not being able to provide a speaker. But Wayne is here, and I will let him please go ahead.
Thank you very much. First of all, I'd like to thank the chair and the vice chair and all of you for the opportunity to talk about this issue. I think it's an important issue that does have significant impacts on the price of health care and price of health insurance, and innovation itself in the space of new drugs and new treatments and therapies. So basically, to start with, just look at what are patents, what do they do, what they're supposed to do, and where we really are. And they're sort of distinct from a property right, say, as physical property, but it's more of a regulatory framework to promote innovation. And there's a lot of capital, particularly in the pharmaceutical world. It takes a lot of capital to produce drugs and get new drugs to market. It's a lengthy process. It can take 12 to 15 years. So there's a lot of investment that goes on. So the patent gives the protection of a certain period of exclusivity that allows those drug makers to then be the sole provider in that market, and that generates the profits that can support the R&D and support new research and move forward in that space. At the same time, once the patent is done, once your patent is over, that knowledge goes to anyone, and that's where the generic drugs come in, where they can produce and compete with the original brand name drugs at a far, it tends to lower prices very quickly. If one generic gets into the market, there's about a 20-30% reduction. Two, it comes down to 50, and you can drastically drop. If you get 5 new generics in the market, prices can drop down by 70-80%. So that's the way the market is set up. But what has happened over time is there's been a certain type of amount of gamesmanship that happens. And what we're seeing is what we call patent thickets, where you'll have a blockbuster drug, and that blockbuster drug can have up to 100 patents on it. So that makes it difficult for anybody to get into that space and compete with that brand name drug. And as these patents sort of protect that drug, you see delays in competition, you see it harder for generics to get into that market, and a lot of these patents are not as inventive as the original. We have, there's primary patents and secondary patents. The primary patent is the active ingredient, the chemical that makes the therapy happen. Secondary patents can be anything around that. It could be the manufacturing process. It could be, you change it from a tablet to a once-a-day tablet to a twice-a-day tablet, or you change it from a pill to a capsule. All of those things can be patented, and they start to pile on. And each one of those provides another extension of exclusivity. So you end up in a situation where we, in the United States, we see drugs being delayed further than they are, say, in Europe, where some of these practices aren't allowed, where important new drugs and biologics get into the market much quicker because they're not playing the sort of the gamesmanship that we see here in this country in terms of patenting. So first of all, what does this mean? It means it has an impact on innovation, because if you are a new drug company and you're trying to compete and find a way to get into the market where a brand name has a patent thicket with hundreds of patents protecting its products, it's hard for you to get into that market. It's hard for you to innovate and provide new products, because there's always a threat of litigation from the brand name manufacturer. And it's a cost on consumers and taxpayers and healthcare providers, because all of these things extend the higher prices, because you don't really see price cuts in these markets until the generics actually get into the marketplace. And the longer you can delay the generics from getting into the marketplace, the harder it is to innovate, and it's harder. Those are costs that are paid by taxpayers, patients, and all healthcare providers and healthcare programs. And then there's an impact on competitors. If it's hard to get into that market, we're not going to see competition as in any other market driving prices down and meeting, just seeing how the economics play out. You don't see that in a situation where you have these patents. And some of these examples, for instance, Humira, which is was a huge blockbuster drug. It had over 100 patents on it. 66% of these patents were filed after FDA approval, and it led to $87 billion in additional revenue before the patent ultimately expired. And that drug, the generics for that drug were available 7 years earlier in Europe than they were here, just because of the way the patent system works here. Revlimid is another one where 74% of the patent applications came after the launch of the product. So these are sort of continuation patents that you're not really inventing anything new. In fact, if you issue a continuation patent, you're not allowed to make new additions to the patent. You just say there's a new claim on that old patent. So there's a lot of things that are happening in this space. Again, Eliquis and Enbrel, those are another two, and it was 7 to 10 years of delay compared to Europe getting these things into the market in the U.S. So you have all of these blockbuster drugs, and we want to see the brand name manufacturers innovating, because they do produce probably the best drug in the world. But when you have all these patents and the sort of the gamesmanship that goes on, it makes it difficult for the providers and patients to enjoy the benefits of these and have access to drugs at an affordable price. So looking at these things, I just want to wrap up real quickly. One of the things, three things that are big challenges here is, these patents and the patent thickets keep drug prices artificially high. So that's the first problem. The second, you delay competition, you delay the entry of generics, and again, that's an impact on the system of healthcare and who has to pay those prices. Particularly, if you compare how that plays out in the United States versus in other countries. And the third area is you actually end up diverting resources away from real research and development to more of a monopoly protection system, where you have these patents, and if you have a blockbuster drug, you're talking about tens of millions of dollars for every day that patent is extended. So brand name drugs, they have a strong incentive to put these patents out there to keep these blockbuster drugs in place. But when they do that, that's taking R&D away, or resources away from R&D on new other innovative things. So you end up investing more in monopoly protection versus innovation and new therapies. So those are some of the challenges. And how do we fix this? I would say there's two things. We want to make sure that when patents are issued, they're issued for real, inventive, novel uses. That's the first thing. Second is, the patent system's not perfect. We get bad patents in the system. So we need a way to find where those weak or invalid patents are and get them out of the system efficiently. So those are the two most important things we can do, I think, to improve the way the patent system works. And so we need a way to review those patents. And then I would say another area we could look at is sort of promoting clear pathways for generics to get into the marketplace, particularly in the biosimilars, which are the more complex drugs, it's not as clear-cut as it is with the small molecule drugs, which are the older drugs that we all are familiar with. So biologics, they're harder to manufacture. There's a lot of overlapping patents there, which are probably really more valid. They're not these like, well, we're going to change it from a tablet to a pill, so we need a new patent. These are complex manufacturing issues. But identifying a pathway to get into that space, I think, is very important in terms of trying to improve the process and make the system work like it's supposed to. Just what's happening in Washington on this. The Senate passed the Affordable Prescriptions for Patients Act in the summer, and that is one way to get at the patent ticket. This is a bill by Senator Cornyn, and that was specifically addressing the role of patent tickets and how to get out of that. There's two others, the Patent Eligibility Reform Act, which I think takes things in the wrong direction by making it harder for competitors to get into the market. That is sort of floating around. It came up for an early hearing, and they were hoping it would be done by the end of the year, but that has not happened. So I think that'll be a live issue in the next Congress. The Prevail Act, just on Thursday, that was passed. And again, I think this one takes it in the wrong direction. It makes it harder for a post-patent review. There's something called the Patent Trial and Appeal Board at the Patent Office, where if there is a problem with a patent, you can take your case to the Patent Trial and Appeal Board. It's quicker than the court system. It's effective. You have 3 patent experts on the board that make the final determination. But the Prevail Act actually limits which cases you can bring to before this board. So I think that one is, in my mind, problematic, but it probably will move forward in the next Congress. And there's another one probably moving forward in the next Congress called the Restore Act, which basically overturns a number. There were some important Supreme Court decisions that sort of laid out patent policy, and it said what, in the past, if you challenge a patent, you could automatically get an injunction issued by the courts. There was an important Supreme Court decision on eBay, which the judges actually said, no, you can't automatically do an injunction. You have to follow these processes. So the Restore Act would overturn that and make it much easier to get injunctions, and those injunctions would impede competition in this space. And again, if all the patents are good, maybe that's not an issue, but with all these patent tickets and a lot of these unnecessary non-inventive patents, if you can get an injunction by claiming there's an infringement on a non-inventive patent, I don't think that helps in terms of innovation or moving the ball forward in terms of getting better therapies to the marketplace. So I'll stop there and happy to answer any questions. But again, thank you for letting me talk about this issue.
Thank you so much, Wayne. I'll start off with just a couple quick questions, if I may. On the secondary patent, I remember hearing a story, and it's a one-source story, so I'm asking you to validate it or not, but where a secondary patent was effectively issued for like an asthma inhaler, because nothing changed with the formulation, but just the cap had like a tab on it that would allow the cap to not fall all the way off when you use the inhaler. So sort of extensions of patents based on something as small as that. Is that an accurate description?
Yeah, I mean, yes, that does happen, and it is. That's a perfect example of these secondary patents and how they're non-inventive, and yet they get the same coverage as the first primary innovative patent, and it allows the extension of that exclusivity and keeps competitors out of the marketplace for a longer duration of time.
Thank you. I'll save my next question in case somebody else had it as well, but we have another question from Representative Meskers, please.
Thank you very much. The question on patent reform, in prior years, the House Ways and Means Committee has reviewed drug pricing, particularly the U.S. versus Europe. And I believe the structural pricing differential is about 3 to 4 times higher in the U.S. for drug pricing. And it's the biggest challenge we face as legislators is working to provide affordable health care. Right now, we seem to be chasing policy benefit managers, but I'm not convinced that once we finish chasing the dollars from policy benefit managers, it ends up in our constituents. If we're looking at patent reform as one of the solutions of that differential in pricing between the OECD countries and the U.S., if we tighten up our regulatory reforms, what would you expect the pricing differential to be for the same pharmaceutical drugs between the U.S. and Europe? Or how close could we get to parity in pricing?
It's a little bit complicated because we have drug reimportation restrictions as well, which is another area that's worth pursuing. But you would see, I think you would see substantial reductions particularly in some of the more expensive drugs. And it does vary. Some drugs, as I said, once you get competition in the marketplace, once you get more than 3 generics actually in that marketplace, you can see 50 to 70% savings on those things. For the more expensive, biologics are much more complicated and more expensive, and those are the Humira, all of those kinds of drugs. So you won't see as much of a drop just because even if you're generic, it's going to cost more to produce those drugs. But I think you would see probably at least 30% drops in prices of these drugs.
So if we're, just to quantify, I know it's a hard number. So we're talking 30%. If we're at a 300% premium, you'd be talking about 210% premium instead of a 300% premium.
Probably for some of those, for the biologics, you're probably in that space. But for example, in Humira, when they did extend their patents through these thickets, it generated an additional $74 billion for the company. So those kinds of costs would go away if you got rid of the patent thickets that we see in the market today.
Okay, thank you. Thank you.
Thank you. Next, we have a question from Representative Oliverson.
Thank you, Madam Chair. So I'm curious, we've been talking about this issue at NCOIL for probably 6 years now. And I know that it's interesting that Representative Meskers is asking questions and I'm asking questions because it's actually our U.S. senators, Senator Blumenthal and Senator Cornyn, that have really led the charge on this for years and years and years. And I guess my question is, do you know what the status is of their bipartisan bill? It's passed the Senate. Is the House going to take it up? Is it going to pass?
A lot of things happening in the House right now, so we're trying to figure out. I think there is enough interest that we will see that. I will say that the bill that made it out of the Senate was winnowed down a little bit. It went after patent thickets, and the patent thickets are still in the bill. There's another practice, product copying, where you get drug companies that make changes, or they'll introduce a new version of the drug and then go out in the market and urge doctors and providers to make the hop to the new drug. And the bill had some language in it originally where the Federal Trade Commission would look at those practices. That part has been stripped out, so now it's purely looking at the patent thicket side of things. So I do see that as potentially moving forward. There's also a couple of other bills. I think Representative Welch has a bill that may move forward that looks at some of these issues. But for now, I would say, and troubling from my perspective, the two that are at the top of the legislative list are the PERA, the Patent Eligibility Reform Act, and PREVAIL. And I think both of those go in the opposite direction, make it even harder to challenge some of these secondary patents that are keeping costs high.
What do you recommend as far as, so like, again, we've been looking at this issue for years and years and years, and the reason that I mentioned Cornyn and Blumenthal is because it seems like those are the guys that really have taken this issue on and have taken all the arrows and, all the attacks and the lobbying and all that stuff, and they've been working on this together for years. I don't see anything that we can actually do at the state level to address this, even though it's just crushing our patients and our consumers. And it's one of these, brute force lobbying things that just irritates the heck out of me about our government system, where we're just piling dollars in the corner and spontaneously combusting them to prevent something from passing that everybody knows really ought to pass. What can we do at the state level?
You know, it is, I mean, patents are, you know, in the Constitution, a creature of Congress. So it is sort of a slight step away to look at what states can do. But obviously, you know, every state, you know, can make the point that their costs, in terms of Medicare costs or Medicaid costs, are higher, and let their, you know, let your representatives and senators know that it's something that you're hearing at the state level. You're hearing from patients or you know, patient advocates who show that these costs are making it harder for people to keep their prescriptions filled. But it is a challenge. You know, I think the debate has been dominated by Senators Tillis and Coons, who are very much in the camp of let's make patents as strong as possible and not look at some of these problems with patent thickets. And I think the last year, at least for me, it's been frustrating trying to work with those guys to move these bills forward. And you know, some of the problems are that patents aren't just for pharmaceutical companies. It affects all businesses, and there's a lot of there's sort of a techlash going on in Washington, where everybody hates big tech, and they are very much in play in this patent dispute over reform. And unfortunately, issues that they're taking out on big tech are sort of bleeding over into the healthcare side of things.
But do they have the same issues in big tech that we have in pharma, where you string together, you know, essentially, I don't know, 500 patents on one process in an attempt to ensnare competition? Because that seems to me to be pretty unique to the pharmaceutical industry.
That is very unique to the pharmaceutical industry. In the tech space, everybody has licenses, and they basically license with each other. So you don't see this. You don't see patents being used as a way to keep generics out of the market. That kind of thing doesn't happen. But the bigger issue, I think, is just the way the committees in Washington are looking at this. They're getting away from the pharmaceutical, and I think we've been sort of pushing the healthcare impacts, and over the last year, I've done a lot of work showing and working to show that the impacts on drugs and impacts on patients are something that you should not ignore. But unfortunately, I think it is not the top issue when the people are discussing patent reform.
Yeah, it's frustrating because I know the manufacturers struggle with it too, because, you know, you were talking about Humira. I mean, a company could be the beneficiary of a patent thicket on one side, and then on the other side, their own biosimilar is getting crushed by somebody else. So it's sort of like one day you're the robber, and the next day you're the victim.
It is, and it's an interesting. The pharmaceutical market itself is kind of interesting because you have all these blockbusters, and when their patent goes away, everything changes drastically. So they call it a patent cliff, where, say, Humira or any of these drugs, as soon as they get close to that cliff, if they don't have a drug in waiting to take its place as the next blockbuster, you know, then the company itself there's going to be a profit drop, and then they have to start thinking, well, rather than innovate, do I just put all my money in protecting this monopoly through more patents? And we do see that happening, where they're investing in keeping the monopoly on the market longer rather than new innovative therapies that can come to market.
Last thing I'm going to say is that this is part of the reason why in Texas we passed a bill last session establishing the Texas Pharmaceutical Initiative, which would allow Texas to basically pursue its own generic equivalents in manufacturing spaces, and to explore the possibility of doing that to try to address some of these bad behaviors. You know, it's not just the thicket issue, but people will also engage in essentially hush money payments to prevent a company from bringing a generic to market after they figure out who's going to get the license to produce the drug from the FDA. I think there was a very famous case with a calcium channel blocker that was manufactured by Eli Lilly, where they basically successfully kept the generic equivalent off the market for almost a decade. Even though the patent had expired and there were licenses issued and the ability to manufacture the drug, they essentially just paid them off to keep the competition out of the market.
It does happen, and in fact, it's called pay for delay, and it's a very common practice where generics will enter these negotiations with brands and decide when they'll come into the market or whether they'll wait so that is another issue that we do see in the marketplace.
Thank you, Rep. Oliverson. We have a few other people who'd like to ask questions, please. Representative Carter?
Thank you, Madam Chair. And I'm going to go along the same line as Representative Oliverson. Since patents are federally regulated, are you saying that there's nothing the states can do to regulate the cost of drugs?
Not in the patent space. I'm sure there's other things states have the authority to do in terms, for instance, one of the things that happened in the past was, and I think a lot of states have their own laws on whether a generic is an acceptable substitute. This was an earlier fight in the drug space where when generics were first coming into the marketplace, if doctors recommended a drug, was the generic considered an effective substitute? So there are things that states can look at in terms of drug pricing, but patent law per se, they can't really do anything about that.
Quick follow-up, please. Okay, in Michigan, we are considering a prescription drug affordability board. What is your thoughts on PDABs?
I think looking at these things, all of that adds to the debate, and I think that would move the discussion forward in terms of focusing on the inherent issue of drug pricing, and that sort of feeds back into the whole dispute about are patents excessively monopolistic and keeping prices higher than a competitive market would. So I would encourage activities like that.
Thank you.
Thank you. In the interest of time, we've got two more people who've asked to ask questions. Senator Boyd, I'll let you go first, and then Representative Meskers, if you want to briefly conclude. All right. Senator Boyd?
Okay. I'll be as quick as I can on this. So I'll disclose in my other line of work, I'm a pharmacist. And so there have been more than one patent extension which have caused pharmacy colleagues to roll their eyes, right? But what I've observed more is now there's this rebating game. So especially with the biologics and biosimilars where it's the pay to play, like I'll pay more dollars in rebates to get on the formulary. I mean, do you have any insight into, is it really the patent issue or this rebating issue that is really driving the price of pharmaceuticals?
I think it's both. I would say the patent issue provides that initial period of exclusivity, which keeps prices higher than they could be. But then you get to the other, once you have that high price, you have every incentive to do everything you can to keep that price as long as possible. And that gives you an incentive to do things like these rebates and getting on the right lists. And those are all debates. A lot of that's more FDA related than patent related, but those are real valid issues that need to be addressed as well.
And maybe that rebating could be addressed at states?
I would think so, yeah. That you have a lot more authority than in the patent space per se.
Yeah, I was just going to suggest in the conversations with that we've had in the past with importing drugs as well from Canada, it seems to me what we're talking about ultimately is either free trade or managed trade, and we're in neither area with pharmaceuticals because the price discrepancies across the world are huge. So is the solution within the patents, or is the solution within protecting our pharmaceutical industry with a certain level of a premium for research and development in the United States to continue their work, but to limit the pricing differential between us and the OECD countries? It seems to me if we're dealing at 200% or 300%, we're subsidizing the world in research and development in drugs. And the only thing we've been able to figure out, I think, at the state level is either some regulatory review of the drugs on the formularies or potentially importing drugs from Canada, which are the same I guess they're all manufactured either in India and China, and they're just priced differently. And I know what your thoughts are on that drug importation.
Sure. It is a separate issue than the patent issue, but it is a real issue, and it does, to some extent, you're right that we are choosing to subsidize lower prices in other countries by the way we price our pharmaceuticals. And you can make the argument that that provides the resources for the innovation and keeps us as a leader in this industry. But at the same time, you should be aware of the fact that you're doing it at the cost of higher drugs for Americans who need prescriptions.
Thank you. Thanks, everyone, for this really robust conversation. And thank you, Wayne, so much for being here. Before we conclude today, we have just a couple other matters. First, is there any other business that anyone would like to bring before the committee? Okay. In the interest of this being the state and federal committee for our discussion purposes, I do have one item to quickly raise and to get on the record. In response to the terrible storms that have hit several states the past few months, I do think it's a good idea to have FEMA and other related parties interact with NCOIL next year to discuss how they've responded to the storms and specifically how the National Flood Insurance Program is working and whether any reforms may be needed. And then if I could just please take a very brief moment of personal privilege. This is my last NCOIL meeting, and I just wanted to stop and say thank you to everyone. This has really been one of the most enriching portions of my time in public office. So I'll just briefly run through a few people I would like to thank. So obviously the NCOIL staff, Tom, Will, Pat, and Jack. For those of you who haven't had the opportunity to serve in a committee chair seat, these guys do all the work. They write the script for you. They do all the research. They keep you up to date on everything. They are diligent and thoughtful and so hardworking, and they put on a great conference, and I can't say enough great about you all. Thank you so much. I would also personally just like to take this opportunity to thank the legislators that I've gotten to work with the most and who have been so generous in training up a yoga teacher would-be insurance expert so that she has any competency in this role. So Representative Lehman, thank you so much. He's already left the room. Representative Ferguson, I can never thank you enough. Senator Utke, Representative Oliverson, Representative Hackett, who can't be with us here today, Assemblywoman Hunter, thank you all. To my Team Kentucky friends and colleagues, you know, everybody knows Kentucky Night's the best night, and for those of you who have gotten to join us, there's a reason why. We work really hard together, we play really hard together. And to everyone in the industry who is here to make sure that we understand all points of view, this is a great collaboration. I really do believe that we do good work and that this is the best of legislation because it really is well vetted and well discussed. So it has been an absolute privilege to be part of this. Hearing no further business, up next is the Property and Casualty Insurance Committee. We're just going to take a 15-minute break to try and move things along since the schedule is so tight today. So again, 15 minutes, that means we'll be back in the room around 20 after. And hearing no other further business, I ask for a motion to adjourn. And a second? Second. And all in favor?
Aye.
Perfect. Thank you.